Hello, everyone. Welcome back to the Homebuyers Bootcamp 2025. This is session 2. Welcome, welcome, welcome. Yay. So, today we have another informative presentation for you. And I'm going to now introduce our special guest, but I have her profile here, Lady Cavelle Johnston, proprietor of the law office of Cavelle Johnston. So I'm going to read her profile and then we will begin with her presentation. Cavelle Johnston is the proprietor of a boutique commercial law practice in Jamaica. She was called to the Jamaican bar in 2008. She actively practices corporate and commercial law, including commercial and residential conveyancing, intellectual property law, industrial disputes, and civil litigation. She represents developers, investors, joint venture partners, and other stakeholders in real estate transactions. Cavell is certified by the Jamaica Special Economic Zone Authority in the following areas: the legal and commercial requirements of special economic zones, SEZs, making SEZs bankable, the technical requirements for SEZ developments, and the rights and responsibilities of SEZs. In 2006, Cavell graduated from Washington and Lee School of Law in Lexington, Virginia, USA, with a Juris Doctor degree and was admitted to the Connecticut Bar that year. She is pursuing an LLM in International Commercial Law at the University of Salford, England, a partnership with Robert Kennedy College in Zurich, Switzerland. She holds a Bachelor of Arts degree in journalism, mass communications, and sociology from Washington and Lee University in Lexington, Virginia. She also worked as an editor of License magazine in New York, where she was widely published. Cavell presents at conferences locally and regionally on diverse topics such as real estate, strategic business partnerships, intellectual property, and brand development. Previously, Cavell served as lead counsel and partner in the civil and commercial departments of Townsend, White, and Porter between 2010 and 2020. She was also an associate at Williams, McCoy, and Palmer from 2008 to 2010. These law firms are located in Kingston, Jamaica. Lady Cavell, we welcome you to Home Buyers Bootcamp 2025. I now hand over to you for your presentation.
Hello, everyone. I am delighted to be here. I am very passionate about sharing law. I don't believe law should be this mystery that we consult lawyers and professionals at the last minute. I believe that these are the sessions where we really are able to construct and deconstruct and organize our business strategies. And it's the best time to do it at the beginning of the year. So thank you for having me. I'm going to quickly share. I'm not the best sharer. And I want to get this on slideshow very quickly, presentation view. So bear with me. Let me organize that.
We're seeing multiple slides, so.
Yes, yes, I'm switching.
All right.
And tell me if you are seeing me now in presentation mode.
We're seeing the main slide and the upcoming slide.
All right, so there's something more I need to do. This is it.
Yes.
This is it now?
Yes, that's it. One slide.
Awesome, awesome. Thank you very much. All right. I like the topic that our host gave to me, the legal requirements for buying a home, but I widened it. Legal requirements for property acquisition, because what I'm going to share with you will work for just about any property that you wish to purchase, whether residential or commercial. So I wanted to include that in case there's anyone listening, whether live now or later, who's wondering about purchasing commercial property, investment property, etc. And of course, this presentation is for informational purposes only and doesn't constitute legal advice, because we know that we've got to give our attorney full facts before you can receive fair legal advice. But this is for us to share and to start an intelligent conversation. All right, so I've narrowed it down to 3 things because of the time constraint. We're going to talk a little bit about how do you qualify to purchase a home or other property. A guide to fees and costs, not exhaustive, but it's the general principle, and how to navigate the sale agreement, just a guide to contracts in conveyancing. So first thing, the mystery is, how do I qualify? You can qualify in diverse ways. I mean, whether you've got a long-standing relationship with a building society, you've got cash in the bank, cash in hand, meaning you can fully engage in a cash sale. You pay your deposit out of pocket, any further payment, and the balance of the purchase price. Or you may need to have mortgage financing. Because of that, you've got an extra hurdle to make sure that you are in order, that a bank will say, we're going to take a chance on you and we like the property that you are looking to purchase and we believe that it is suitable collateral. So in a mortgage finance sale, the purchaser pays a deposit generally out of pocket. Some developers, especially if it's a new development, may require a further payment, generally 5%. So the deposit could be anywhere from 5 to 10%. And I'll go a little bit more into that. The further payment is generally another 5% of the value of the purchase price, to be specific. And then the mortgage institution finances the balance of the purchase price, less any shortfall due to limitations on your ability to qualify. I wanted to do mortgage finance sales first. If you don't mind, I'm going to just alert King Alarm that I am in my office properly. I see that I'm getting an emergency buzz. So if you don't mind, I'm going to mute you just to take that call. I am very sorry, but shortly would have a problem if I do that. So, all right, I see that they're gone because I wasn't able to mute quickly. All right, let me mute now. Sorry about that. So I thought I'd do mortgage finance sales first. So the first thing is, do you have your deposit ready? So if you're looking at a property that's say $20 million, then you're thinking, no, if you're self-employed, a bank is likely to only lend you 90%. So you got to have your deposit of 10% ready. Some people have it on some sort of fixed deposit. You want to make sure you've got a good short window to access those funds if you need to. Then you may be required to make a further payment, as I discussed before. And if you're listening to me and you're overseas, all hope is not lost. Most banks are prepared to lend up to 75% of the sale price to a qualified purchaser who is residing overseas. Now, they may have little rules. Some say you have to have a 12-month history of deposits, but that's not a closed thing. So if you don't have that history, don't be deterred. The key thing is to start the process and have your banker work with you. There are a couple of things I notice when I'm doing sales. I tend to hold up the transaction and frustrate purchasers. You may have pre-qualified, and so you relax and say, okay, I can get a credit card, I can get another credit line or line of credit. But all of those things change your debt to equity ratio. And so when you are pre-qualified and your realtor like Sophia is very happy with you, you found a property and you've got your 10% and you've paid it, and generally the sale agreements require you to come up with proof from your bank that they're willing to take a chance on you. It's called a letter of undertaking. We're waiting on that, only to find out that there are some issues now with your ability to qualify for your loan. We want to make sure that after a conversation like this, you're way more sensitive to how to look the best and be the best applicant for your loan. All of these things change your debt to equity ratio. Even something like switching from having a job where you are paid a salary to being self-employed. Even if you're taking home more or taking home the same thing, it's a different calculation that the bank does generally. And so if you started a loan application and then switch to being self-employed, you want to bring that to the attention of your banker very quickly. Don't wait until they're asking you for your last 3 pay slips. Then you want to say, oh, actually, I'm not going to be able to produce that in that fashion. Because then they'll be looking at your business account and all of those things. After pre-approval, you want to make sure that you have kept the status quo. You've got access to your funds for your deposit and further payment, and you're in close communication with your banker about any changes. I'm going to do a brief note on NHT, but I know that we're other speakers that, will help you more on the qualification of the loan aspect of it. But I just in case anybody is wondering, properties on the open market, once you qualify, you can access generally up to 7.5 million. If you don't qualify that, there's generally a lesser amount, generally something like 6.5. There's also home improvement loans of up to 3.5 million. And this whole mystery of selling your points, I don't know of it. What I do know is that a parent age 70 or below is permitted to assign their benefit to one biological or legally adopted child. So the point system is really when you're trying to qualify to an NHT, into an NHT scheme. That is very specific. But the assignment of a benefit, generally anybody who gives their benefit to you comes on title. So you want to make sure that you put yourself in order to qualify with the persons that you intend to own the property with, not just using different persons as a vehicle to qualify, because then you have an issue of them being applicants. And it's a whole field in itself. And I know Sophia will have somebody speak to you specifically, but you want to make sure, because there are legal ramifications to having people on title. You can't just get them off. As sales. So I touched on before, deposit of between 5 and 10, further payment, funds on hand in the jurisdiction. The sale term is generally 60 to 90 days. That's something that's agreed between vendor and purchaser. That would be you. But the standard, if you're doing a cash sale, it's a shorter length of time. Mortgage finance transactions, they try to get them done in 120 days. And you're supposed to have your document called an undertaking from a bank to say that they're willing to pay the balance of the purchase price within 60 days. Some people will extend it to 70. I've seen up to 75 generally. Source of funds, very, very important. That's why I like when people develop relationships with banks earlier than later, because you want to be able to state the source of funds that avoid delays with a bank releasing funds, especially if the funds are coming in from outside the jurisdiction, because they have anti-money laundering and all sorts of requirements that they have to comply with. So we're making good stride. I know I only have 30 minutes. I want to touch on as many things as possible, right? A guide to fees and costs. Now, there are some partners. I like to say that sometimes we're only as good as the team we assemble. And sometimes people think that, they are saving, but then you actually end up paying it to the wrong person. And all sorts of things. So you want to be very advised. The realtor's job is to walk you through the process of identifying suitable property and giving you the best opportunity to present yourself to a potential vendor. The attorney's job is to make sure that we walk you through the title process. Is this good title? Does the person who's seeking to sell you, do they have the right to sell? Is the matter in estate, meaning that the owner is dead and may or may not have left a will? And so you would be purchasing from the administrator if the estate has been admitted, or you'll be purchasing from the executor if the will has been admitted to probate. So you want to make sure who you're talking to, because sometimes if you're overseas and they've just left somebody in charge, and that person may be just one of many on the title. Sometimes people have a life interest. It's not common, but I'm seeing it now. So the person there has a life interest. So they can't sell without discussion with the person who is the remainder man. I thought it was an academic thing when I learned it in law school, but I've actually seen it where you have to note the death, the person with the life interest has died, you note their death, and then the remainder men generally are now authorized to sell. Sometimes one person has died, you're a joint tenant. So generally you note the death of that joint tenant at the same time you're doing the sale. So it's generally not going to hold it up, but you that's why you need a lawyer. All these little things, these are the nuances that a lawyer walks you through. Searches to make sure there are no hindrances at the National Land Agency. And then we generally, as counsel, say to you, you've got to get hold of a commissioned land surveyor to take a look at the boundaries to see if restrictive covenants have been breached. That's a major holdup in sales, because a lending institution wants to make sure that this is good collateral, that if you're naughty and not paying your mortgage, they can move against the property to secure the monies that they have lent you. So even a slight breach, even an encroachment, meaning somebody has put something, whether movable or not, onto your property. Sometimes it's just the edge of somebody's home, their garage, their dog house, And sometimes it's a letterbox if it's an apartment complex. All of these things, your commission land survey, when he gives you your survey ID report, that's his job to pick that up. Engineers, I'm not leaving that off, because more and more, you're getting a hold of properties that have some age on them. And sometimes the National Housing Trust or your private mortgage institution will say, we want to see an engineer's report, a structural engineer's report. We want to make sure that everything is in order. Sometimes your valuator will say that because he has seen cracks on the property. And so that's not his forte. And he'll say to you, you know what, ma'am, I think somebody else needs to have a look. Your banker. That's the person you want long before you're even thinking of purchasing property. You want to have a relationship with. You can tell him what's changing in your life, even things like getting a divorce, all of these things that have financial implications. You want to share that information with your bank. Insurance. Wow. Very, very important, because generally, in order to close a loan, meaning you've been approved for a loan, but the loan has not yet been dispersed, the bank wants to see proof of your ability to pay peril insurance. And I have some numbers to give you in the slides to come. And also life insurance, which the earlier you can get life insurance is generally more helpful. You pay a lower amount for it. So if you are buying a $30 million property or a $20 million property, you want to be able to secure some life insurance to cover that. You can get that directly from that lending institution. They generally have some sort of partnership, or if you have an existing relationship with your insurance agent before for other types of insurance, that's a conversation you have with them. Some banks actually will require you to assign pre-existing policies to them, or some banks will just say, okay, just make sure you've got it. And different things will obtain depending on the institution. So that's why this is informational only. I'm sensitizing you and enriching your ability to have certain discussions. Let's look at fees. The surveyor, properties in urban areas, meaning like more densely populated, more modern buildings, somewhere between 0.25 to 0.3 of the market value. You can expect to pay that if you're the purchaser. Rural areas may be subject to a fixed fee, but when he gets on site, he generally indicates that to you, or unless you've shown some sort of diagram before, and you can work that out with him. The engineer, again, determined by location, type, and size of property, and the average cost for reports in urban areas are between 90 to 120,000, and I'm dealing with Jamaican dollars. Again, borne by purchaser. The valuator note. Sometimes you can get a fixed fee, property value of 15 million under, maybe a flat fee, 45,000. But if it's in excess of that, there's a more complicated calculation, and it's not one way of doing it, but you can estimate some sort of $3,000 dollars per million in your computation. Title searches, a must. That's $500 generally. Caveat search is $1,000. Again, all this is the purchaser's responsibility. When you get now into the sale, you have the joy of sharing some of the costs equally between vendor and purchaser. Like stamp duty, $5,000. Generally, that's shared. Transfer tax, that's the vendor's responsibility by law. So he's got to bear the 2%. Registration fee, shared, 0.5 of the market value of the property. Preparation of the agreement for sale. This is separate from legal fees payable to your attorney. Generally, that's a separate matter. So it can range depending on the value of the property, anywhere from 50 to even 80,000, all the way up to 250, depending on the value, the market value of what you're purchasing. Attorney's fees, 2.8 to 3%. That's an average, but it's always subject to discussion. And I think attorneys are willing to have a discussion with you based on what is happening, but I'm just giving you what's an established principle. Miscellaneous fees, that's preparation of your letters of possession to the various agencies, JPS, National Water Commission, to say, hey, I am the new owner. That's a shared cost as well. Right. Realtors fees, generally 5%, but I've seen some realtors go as low as 3%, but the standard really is 5%, and that's borne by the vendor unless you as a purchaser, you are subject to a buyer brokerage agreement, which is a newer thing for Jamaican markets, but it's where the buyer has agreed to pay a set fee to have suitable property identified. Mortgage processing fees. A lot of
One
people are
moment, Lady Cavelle. As of right now, Keller Williams Jamaica, we don't have any buyer brokerage agreement, so you don't have to worry that you have to pay me to search. All right?
And I have to throw it in because it exists.
Sure.
All right. Mortgage processing fees. Sometimes people are unprepared for this one. So you've saved for your deposit, you have managed to find your further payment, you have paid the lawyer and all these wonderful half costs. And guess what? In order to close the loan, you are now hearing for the first time that you've got to pay mortgage processing fees. So after this discussion, we know that you're going to create your spreadsheet and have these things assessed so you know what you're saving toward. Generally, 1 to 2% of the property value, and you have until generally you're closing the loan to pay for that. So that's not a first up fee. But what I do want to say is that generally you've got to have that in your account for the loan to be closed, and they freeze that until they're ready to close the loan. 1.85 is kind of what I've been seeing now. Peril insurance, that's the standard at this point is 0.8% of the sum insured. And again, generally required at the end of a successful mortgage loan application, but before disbursement, going by the purchaser. Life insurance, that's open market. Depending on how early you had sought insurance before, you could get 12.5 million for 12,000, but you could get it for 25,000, depending on what's happening. So you speak to your insurance agents for specific quotes. So fee summary: cost of vendor, transfer tax, half cost the agreement for sale, half cost stamp duty, half registration fee, half miscellaneous attorney's fees, third party fee to realtor, and cost of purchaser, half cost again, half cost the agreement for sale, half cost stamp duty, half registration fee, half miscellaneous fee, attorney fee, third party fee, survey evaluator, engineer. Right. How am I doing on time? Because now I want to take you through the sale agreement.
You can go ahead.
All right, do I have, how many more minutes do I have?
It's now 5:02, but we had started a little bit later.
All right, good.
About 15.
Mhm. So step one is the great agreement for sale. Everybody at this point now needs to have a TRN. You've got to share with your attorney your proper name as it appears on your TRN. So sometimes it's a little different on your ID, your driver's license, or you've been married and all of that stuff. You've got to check what's on your TRN. Generally, these things can be handled by some sort of reconciliation clause, but you just want to make sure that you've got that squared away. The negotiations with your lawyer, well, you'd have already worked out the sale price. So generally, the attorney doesn't touch that part, but we work out the cost of the preparation of the agreement for sale. And we agree on the timing and notice clause. Now, timing is very important because many sale agreements have something called a forfeiture clause that says if you're late with anything, they can actually forfeit your deposit. And by law, they can. Can't take more than 10%, but forfeiture is actually legal. It's just sad. But you want to make sure that you're very prepared to meet the requirements of the sale agreement. So you want to know what's in it. What are the timelines? If you don't understand it with your attorney, just ask her to just break out a sheet with just when what is due. Notice, how notice is to be given, just in case some sort of notice has to be served on you. It will be in the agreement as to whether the notice is going to be served on you directly or your attorney. So then, step one, you sign your sale agreement and the instrument of transfer in advance. I mean, the sale it's not going to be transferred unless you have met your financial requirements. But generally, because some purchasers are overseas, you get both documents at the same time. Generally, when you sign, you have to pay your deposit and the half cost of the agreement for sale. And if GCT is applicable, meaning the institution is authorized to collect GCT, that will be added. Then it's countersigned by the vendor last. My diaspora clients sometimes have a challenge with that. You have to sign and I have to pay first. I'm like, yes, it's actually a condition precedent. That's what that special condition wants. That says it's a condition precedent that before the agreement is considered valid, both parties have to sign and the deposit paid. Step two, vendor's attorney uses deposit to pay the stamp duty and transfer tax and submits the transfer for what we call cross stamping at a later date, generally when we know that you are able to finance the balance of the purchase price. So the stamp office is the friend of the lawyer because we send it down first to be assessed. Generally, we know that it's going to be 2% of the value of the property that is going to be paid, but you can find yourself in a position where you're getting a deal, but the property is worth more. And so depending on what the terms of the agreement says, the vendor can actually come back to you and say, you know what, I don't want to proceed because I'm not going to pay this extra transfer tax. But depending on the wording of your agreement for sale, which is why it's so important to have a lawyer, it could have that you would advance that difference and it be treated toward the purchase money so that the sale wouldn't be aborted. So the fees would be paid all out of the deposit and you would proceed. Now, this is the more tricky part. Mortgage finance purchaser where vendor has no mortgage on title. So the purchaser gets their letter of undertaking from the financial institution generally within the 60 days. Then the vendor's attorney gets all the property tax things squared away, generally by showing a property tax certificate. There's generally have to be proof of water bill and then all of the things that we need to send to the purchaser's lending institution to include the duplicate certificate of title. There's a reason why we call it duplicate certificate of title. It means that there is one at the National Land Agency and you have the other one to it. So duplicate doesn't mean copy in this case. A duplicate certificate of title is an original title. It's just the one that is in your hand versus the one that is on the register at the National Land Agency. Then the purchaser's lending institution is going to lodge the transfer document and title at the same time they're registering their mortgage. Once this is completed, the mortgage institution will then send the sum that they promised and guaranteed they would send in the letter of undertaking. And so what we have is a system where your attorney is a stakeholder. We want to make sure that he who has the title doesn't have the money. We can't afford for the vendor to have your money and the title. So you want it to be in the hand of the lawyer, and then at specific times, the monies are sent over, the title is exchanged, we know that your name is endorsed on it, then we pay out. And when you have a mortgage transaction, those documents go from your attorney and into the hand of your mortgage institution, and they launch them all. Cash purchaser where vendor has no mortgage on title follows a very similar flow. But upon payment of the transfer tax and stamp duty, purchaser has two options: pay the balance of the purchase price at this stage, or the purchaser's attorney may be permitted to provide a letter of undertaking that, look, I've got the money in my account, so once the transfer is lodged, I'll pay that over. All right? Good. Mortgage financed purchaser where vendor has mortgage on title. So you know you're dealing with two financial institutions. That's even a little bit more dicey now, because the first institution, which is the institution that has the title in their vault and they have an unpaid loan, you've come to them to say, guess what? I am going to sell the property and I'm going to pay you out. So give my lawyer the title, give them an advance, discharge of mortgage document, and any other document that is required. They're going to have it in safekeeping, but they're going to show the other side. On the strength of that, the other side is going to pay the money. And then when I get that money, I am going to pay you. That's why your lawyer is so important, you know. And that's why sales can take up to a year. Because look how many people we have into this game now. We've got little things that can hold up a sale, for example. What is the final balance on your mortgage? I've seen sales being held up because the vendor is overseas and the bank is saying, we don't have any money for the fee for the status letter. So we need somebody to come in and pay that. So of course, as the nimble attorney, I have to just send somebody over to quickly get that going. Because I have got to get this statement of account so that I can say, I hereby give you my undertaking that I'm going to pay you this and any other sum at an agreed rate of interest as set out in the mortgage documents. Once you just go ahead and give me the title so I can send it over now to the purchaser's bank so that they can register their mortgage, because we're removing one mortgage and we are now getting into another mortgage. These are all the little things that these players walk you through so that you can go from concept to key. And that's why I love being and sharing in presentations like this, because people wonder, what's the lawyer doing? Collecting money. What's the realtor doing? Collecting money. The realtor is my right-hand man. I'm asking them for information. We're going back and forth and we're working to make this thing go as quickly as possible in your favor. So this is a wordy slide, and that's why I just kind of explained it as how I would explain to my client when they're in the office. All right. Mortgage finance purchaser, where vendor has mortgage on title. Same thing. Purchaser's mortgage institution registers mortgage, registers transfer, registers discharge of the old mortgage. Upon completion, purchaser's mortgage institution pays over the sum contained in the letter of undertaking to the vendor's attorney. Vendor's attorney must pay the sums to the vendor's mortgage institution in the sum stated in their undertaking, as set forth in what we discussed above. Last step. At the end of all sales, notwithstanding the type of sale, the vendor deducts their fees, vendor's attorney deducts their fee and any advances made. This issue of advance is generally arised when your property tax is not paid up. Somebody has to quickly handle it for you. Generally don't like to do that. So we tell people to start paying up your property taxes so that you don't have this problem of trying to say, Lord, I can't manage, you know? Sometimes it might be acceptable to give an undertaking. The vendor's attorney might give an undertaking to pay the outstanding property taxes out of the purchase price. I've seen that done as well. And the net proceeds are then sent by the vendor's attorney to the vendor, and the vendor's attorney provides the purchaser with the letters of possession we discussed earlier, and that's dispatched to the utility company so that everything can be transferred over into your name. And it's not just utility companies, it's the change of name on the valuation rule, things like that. You notice I have an ND, the vendor's attorney, to include in the sale agreement authority to remit realtor's fee for added protection. I generally refer to same in the retainers agreement because you've got your returner, your realtor running up and down and waiting to be paid at the very end of the day. Now it's over to you. And if I get time, I am happy to answer any questions.
All right. Thank you so much, Lady Cavelle, for a very informative presentation, very comprehensive. All right, so now is your chance by raising up your hand to ask your questions. Ask your questions, everybody. But raise your hand first, that I'll see who would like to start off. Don't be all shy now. Questions? Yes, Nadine.
I'd like to think I was that clear that everyone squared
Nadine?
away.
Nadine, you want to speak?
I'm not entirely sure if it was discussed in this session, but I want to ask about second home financing. So you are already
That's a question for tomorrow's session
okay, great.
when we have our mortgage financing rep on.
Thank you. Appreciate it.
Nadine.
Hi, afternoon. Thanks for the presentation. I need some clarity surrounding joint tenants. If family members have a property and brother, sister, and brother suddenly died, but on the title, brother and sister was joint tenants and brother suddenly died. How, if that property is supposed to be sold, would there be any issue?
No, not at all. I discussed it briefly. So
Yes,
when
you
you
did.
have joint tenants, it means that the last man standing takes it all. So you simply notify the National Land Agency by way of an application to note death that the other person has passed, and that will explain why on the transfer you're the only person signing.
Okay, what if the deceased had beneficiary? The joint tenant thing by law is that the last man
Doesn't
standing,
pass through, yes, it doesn't
it
pass through
doesn't go
the
to the benefit.
estate.
Oh,
Yes, that's why you have to know the difference. So there's joint tenants where it's a last man standing takes it all. It's called the right of survivorship. So the survivor takes it all. But then you have
oh,
tenants in common where immediately the two or more tenants have two separate interests that they can actually leave in a will. So
oh.
that's why sometimes when people come to a realtor and they show them the title, the realtor really has to know this difference and say, wait, you're not in a position to sell yet because this is going to be more than an application to note death, which can be done at the time of the transfer. All of those papers can be sent down as at one time to a mortgage company or to the attorney who's doing the transfer. But if it's tenants in common, the other person has to check if the person who died has a will. And if so, the executor needs to get that will admitted to probate and get a grant of administration. And if they didn't leave a will, somebody has to apply to get letters of administration. in order to be able to transact on behalf of that estate. So it's a little more complicated. But in the situation that you told me about, if the title is saying joint tenants and one joint tenant has passed, then you do an application to note death. And that can be done at the same time that the property is being sold. And you'll see that sometimes in the sale agreement, it says this agreement is subject to an application to note death of such and such. But again, I tell people, if you've got the time before and you know you're sensitized to it, if that is the situation, you take care of that long before you come to a realtor to say, I want to put my property up for sale.
Okay, thank you.
All right, we have another question in the chat. Are attorneys necessary for purchasing homes in new developments?
In new developments, that's a very good question, because sometimes the new developments move so quickly. And a lot of the, well, I wouldn't say a lot, some of the developers don't negotiate a lot in relation to the terms of the agreement. So it's kind of a take it or leave it. We've got a lot of persons waiting to buy this home, so there's not a lot of negotiation. But I am hoping that when you look back at this presentation, you realize that the agreement for sale is one part. Even if you're not able to do a negotiation on it, for the attorney to explain to you what's in it and the deadlines and the ramifications, including things like forfeiture clauses, where if you don't pay things in time, there could be an interest penalty, but there could even be more, that you may forfeit your entire deposit or a half of it. So it's really, the lawyer is doing more than just negotiating. If you're listening, they're telling you, listen, this is what is happening here. These are the deadlines. And if you don't meet something, this is what could happen, so that you're better able to have a discussion with the various players that you need to support the game, as we discussed before.
Thank you, Lady Cavelle. Any
Another
other
question?
questions? So we have until 5:30. It's 5, so you have like 11 minutes. So please come through with the questions. Because remember, I'm not an attorney, so subsequent sessions. Okay. No questions?
All right. Well, you know where to find me. I
Now
will
I'm
leave
going to share that now.
my contact
Also
information
for
in case
for
anything
it to
comes to
be.
you.
Yeah.
I can be reached on cell at 416-6307, but it's easy to just find me on email, consult at cavellejohnstonlaw.com, and there's a T in my name, Johnston. And there's also my website, and the office number is 665-7638. All right.
I've also shared it in the chat.
Awesome.
So make sure that you just copy this down. And of course, in the WhatsApp group, which I've been sharing the link, once you join there, any contacts or any other resource, we'll share them there. And don't worry, that WhatsApp group is not interactive. It's strictly for sharing information resources, particularly when we have upcoming sessions that will be beneficial to you. All right, so if you hold on, somebody just.
Wait, I wasn't looking in the chat, Let me see if it was
Okay,
anything
big
directed to me.
thanks. Yes, Cavelle Johnston, Sophia Terrelonge, useful information from K. All right, you're most welcome, K. So if you have no
Awesome.
further questions, yes, we'll just stop the recording here. And of course,
Wait, there was a question. It says, let me see. I came to the session late. What are the attorney fees?
oh, they sent it directly to you. Hold on. It was a
All
direct
right.
message to you.
I saw that one. I just saw that one. So let me just back up then. Attorney's fees.
Mhm.
Let me minimize this.
Sorry, while you're checking, the WhatsApp group is which How you get onto that group?
I'm going to share the link again. You simply click on it because in these scenarios, and given that I'm quite busy,
Okay.
if I do the usual thing of adding your name, everybody's name, so that I can add them to the group, I'll not actually do the work of the
Yes.
realtor associate.
Okay.
So the link, legit, Samir, click on the link, join the group. Not now got to your phone, not now got to your computer, not just click the link, join.
All right. So
Feel free
if I
for those
could
of you
address
watching on
that
YouTube.
question, then so the attorney's fee is generally 2.8 to 3% of the sale price. And there's also that's to your attorney. So that could be the vendor generally has to pay their attorney and the purchaser pays their attorney two separate fees. But there's also the cost of the preparation of the agreement for sale, where they charge an additional fee. The vendor's attorney is going to charge an additional fee for that. And that can be anything from half of 80, could be even half as 50, depending on if it's very, very low as the market value, all the way up to a scene 250,000. But those are for, larger properties like 80 million, 70 million. Generally, if it's something between 30 million, you can expect fees of maybe like 100, 120, and then that is split in two. And what I was saying is that the reason for the attorney's fee is that it's the attorney's walking you through the due diligence part of it. And I really don't like when lay people take on due diligence, because what something means in law is not necessarily what is the common sense meaning of it. And so you might think you're so cool. Man, I really went through this thing, man. I read it and it makes sense. And there's a thing saying, oh, that if you don't meet the 60-day letter of undertaking deadline, you're going to forfeit your deposit. Your attorney needs to point out to you that we're going to try to negotiate with the vendor as attorney to say, let's take that out and let's just work with an interest penalty clause and make it something reasonable. Or I might just say, look, based on what the client has told me, I know we're not going to be able to make 60 days. You couldn't get 75. So that's the whole job of the attorney. And as I said before, even when you can't negotiate a lot with some of the agreements that are kind of a little less flexible, the developer is a little less flexible. Or I should say widely, the vendor is a little less flexible. The attorney is walking you through the deadlines and telling you that, okay, well, basically have a conversation with your surveyor and get him to start working quickly because we're working with a fast turnaround. And the bank is probably going to need that same valuation report and that surveyor's ID report. So you're getting it not only to ascertain the value or to ascertain is there's a breach or no breach, but rather to also satisfy some of the conditions of getting your mortgage. So the faster you have those in place. Another thing too is always make sure you use the persons who are on the bank's approved list. So if it's a surveyor, one that the bank approves, a valuator, the one that the bank's approved, don't just use your friend because you might find that they're not chartered lands. And you have to spend the money two times, So that's why I say it's a partnership. That's why I made that slide. I'm like, this is the partnership slide. Realtor, attorney, commission land surveyor, engineer if needed, valuator, banker, your insurers. And when I actually was drafting this slide, I had any other financier because sometimes you definitely need a hand to make up something. But it's a very important thing. Buying property builds generational wealth. It allows you to leave a heritage if managed properly. And I'm always happy to guide persons through that process.
I have another question coming through. Oh, so your mind start activating now with the questions toward the end. I've explained. No worries. I'm here. This is my personality. Don't take this. Don't be angry, okay? Explain the escalation fee.
Yes, send me the question again.
The person is asking you to explain the escalation fee. This is the same person who asked if she needs an attorney for developments.
All right, so tell me the full question because I'm not seeing it.
That's all she wrote. Explain escalation fee.
Oh, good. All right. So generally in a new development, you get in at a point where it's early in the construction. It's a live process that is being managed by the builders. And at the end of the day, before you can get your certificate of practical completion, there's a quantity surveyor who's looking at everything. So we know that costs will go up. So we build in, the developer's attorney will build into the contract something that says that you can expect an escalation fee, but we're going to tell you what it can't go past. And generally, that's 10%. So if you think about it, you've got to, if you're buying into a new development where it's, you're getting a first time construction and the construction is underway, meaning you didn't look at the finished product, you've got to have in your budget up to another 10% or whatever that little section in the contract says that escalation is capped at. I have found that when you buy in earlier, you may have to be a little bit more sensitive to that. But if you're at the other end, maybe a little less. But whatever they have put in the contract is whatever you need to have, because you're going to need to have that before you're going to be able to get your keys, even if it's a cash finance transaction. So you've got to have that extra. And for those who are getting mortgage financing, sometimes you even have to return to your bank to get a second loan if you didn't build that amount in when you were looking at the first application, because sometimes people are just thinking about the balance of the purchase price, like whether it's 95% or it's 90% or 85% because you've made some sort of other further payment or any other figure. But you really want to have your attorney discuss with you what did they negotiate for you or with you in relation to the escalation, so you have an idea of, boy, is this something I have in savings? Because if not, I'm going to add it to my loan amount. If I don't need it, then maybe closer to the time, might delay the loan a little bit, but you can reduce the amount. I've seen people do that. But of course, your banker will guide you first, and I'm just giving you an idea of some of the scenarios. But that's why escalation is lawful, because it's a first-time construction, and they know that they're actively purchasing material. And so when they calculate what it is their cost to build the development, they don't want to get into a situation where they're in overruns, but they're locked into a particular purchase price that causes them now to build this thing at a potential loss.
Okay, so we're right at 5:30, but a question that came in, the person said they joined late, so they wanted to know what's the role of the realtor versus the attorney. I'd gone through that yesterday, but I don't know if they want to hear it in your words as well. I don't think they...
Right, no problem. Let me see. I joined it. Was it possible for a brief of the role of the realtor versus an attorney? Yes, I love this question. No, the job of the realtor is to walk you through the process of getting something that you like in view, meaning they help you look at properties and distill the purpose for what you want the thing for, especially if it's commercial property. So, you'll say, boy, I'm going to, I want an office. He said, but is it for what kind of business? Is it for a lawyer's office? Or is it for, you want to have commercial traffic? You're going to be depending on foot traffic. So your realtor is the person that you have this conversation with about the purpose for what you want, whether it's personal real estate or it's resident or it's commercial, meaning residential or commercial real estate. But then beyond that, the realtor takes you through the process of getting pre-qualified, and we want a good pre-qualification. We don't want one that when we start the sale agreement, and you really go now with your papers to the bank, they're not willing to lend you anything. So the realtor walks you through the whole thing of selling, getting your TR and all of those ID copied, discuss with you who you want to have on title. Is it that you're looking potentially to nominate someone? Because some people just want to go ahead and qualify for their loan and then want to add somebody. All of these discussions you have informal with your realtor. But I actually said in another presentation that realtors are the person who get to follow up with you to make sure that you stay on track. So a good realtor doesn't just say, great, I have sent over the offer to purchase. I see that the two lawyers are in contact. I'm going to fold my hands and collect 5%. No, that realtor has to be sensitive. That's why if you
All the way
really
to
are
post
working closely with your realtor, you'll share
and
the sale
beyond.
agreement with them. So the realtor now is sensitive to the timelines. And the realtor said to Ms. Johnston, I'm just checking you on this matter. And I said, I can't find the client. And this is what is happening. They're able to run on the ground, locate the client. The client will say, boy, I'm trying to get the valuation report done, but I can't seem to get access to the property. The realtor is the person who will get on the phone and speak with the other realtor to say, if there's another realtor to say, how can I facilitate this process? How
The
can I
access.
assemble the team that needs to go? Might be your site engineer, might be your realtor and your surveyor. So the realtor is helping me as the attorney to liaise with you and to safeguard the timelines to keep you out of interest and potential forfeiture. So they're doing two different jobs. While the realtor is not going to sit with you and go through a sale agreement, the realtor can help you liaise with the third parties sensitive to these great deadlines that are looming to get the thing done. Am I speaking out of turn, Sophia, or that's how you feel?
No, you're not. No, you're not. You're not.
Yes. Even things like getting the package overseas, to the client where something needs to be signed and monitoring that process. If there's a breach on title and an application has to be started for a modification of restrictive covenant, you need to be chatting with the realtor to say, okay, we've got a breach now. We have gone into a next set of stuff. Help me. So when that realtor is collecting that 5%, it's not for just resting on their
And it's not
laurels.
5%. Remember, it's a four-way split because
Yes, yes.
every realtor associate has a broker. And there's usually like four people on each side of a transaction. The buyer side, the seller side. So about I think 5%. Oh, Sophia, I don't know. It's a four-way split.
Listen, Sophia, I wasn't going to go into your business, but I have to just,
But I'm explaining.
I just had to let
Because
you speak
this
because,
20%.
there's a lot of hidden work and a lot of sensitivity, and it's a partnership. And it's a time-sensitive partnership. And so we're really grateful for this kind of forum that you are encouraging, Sophia, because sometimes when you're growing up, some people used to hide the book in the library and hide this and hide that and don't want to share information, but it doesn't help us in the long run because at the end of the day, if there's no product, if there's no partnership, there's no product.
Exactly. All right, so we're 5 minutes over. Thank you all so much for coming out. Again, I've shared Lady Cavelle's information in the chat, but let me just share everything all again in just one chat so that in the event that you weren't following along before, you'll have everything. All right, so give me a sec. So, so that's her details, and then you have the link to join the WhatsApp. So if you copy all of that last chat that I sent out just now, just copy it, and it will be in the clipboard for your of your phone or your device. Then you will have everything from this session. Please join the Homebuyers Bootcamp WhatsApp group. Okay. You can stop sharing the presentation now, Lady Cavell. Oh. And yes, thank you so much for your response, Lady Cavell, the last. Thank you for a very detailed presentation. Yes, grateful, and she says, grateful to be here. And yes, thanks, Sophia Cavell, for the presentation. Yes, you're most welcome. I'm here to serve. We're all kingdom people, myself and Cavell, so we are very service oriented. All right, so let me just, one sec, pause the recording, and thank you so much for being here. Thank you very much. All the details that you need, they're in, for those of you viewing this on YouTube, they're in the description box below. All right, so bye.